Rule number 11, pleas. Please. Rule number 11, pleas. Generally, a defendant personally or by counsel may plead guilty, not guilty, not guilty by reason of insanity, in which event a not guilty plea may also be entered, or with the consent of the court, nolo contendere. Contendere. Nolo contendere. B. Pleas of guilty and nolo contendere. The court shall not accept a plea of guilty or a plea of nolo contendere without first determining that the defendant has been advised of all the rights set forth in Rule 5A2, and also determining 1. That the defendant understands the nature of the charge and the elements of the offense to which he is pleading and the effect of his plea. 2. That the plea is voluntary on defendant's part and is not the result of undue influence or coercion on the part of anyone. 3. That he understands the right to trial by jury and that he waives his right to trial by jury on all issues. 4. That he understands the possible penalty or penalties. 5. That the defendant understands that the court will not be bound by any representations made to the defendant by anyone concerning the penalty to be imposed or the granting or the denial of probation unless such representations are included in a formal plea agreement approved by the court and supported by the findings of the pre-sentence report, if any. 6. That there is a factual basis for the plea. If the plea is entered as a result of a plea agreement, the court shall explain to the defendant and satisfy itself that the defendant understands the basis for the plea agreement, and that the defendant may then waive the establishment of a factual basis for the particular charge to which he pleads. 7. That in Class 1 felonies where the plea of guilty is to a lesser included offense, a written consent shall have been filed with the court by the district attorney. C. Misdemeanor cases. In all misdemeanor cases except Class 1, the court may accept in the absence of the defendant any plea entered in writing by the defendant or orally made by his counsel. D. Failure or refusal to plead. If a defendant refuses to plead, or if the court refuses to accept a plea of guilty or a plea of nolo contendere, or if a corporation fails to appear, the court shall enter a plea of not guilty. If, for any reason, the arraignment here provided for has not been had, the case shall for all purposes be considered as one in which a plea of not guilty has been entered. E. Defense of insanity. The defense of insanity must be pleaded at the time of arraignment, except that the court for good cause shown may permit such plea to be entered at any time before trial. It must be pleaded orally, either by the defendant, if they're insane, then how can they follow these rules, or by his counsel in the form not guilty by reason of insanity. A defendant who does not thus plead not guilty by reason of insanity shall not be permitted to rely on insanity as a defense as to any accusation of any crime, provided, however, that evidence of mental condition may be offered in a proper case as bearing upon the capacity of the accused to form specific intent essential to the commission of a crime. The plea of not guilty by reason of insanity includes the plea of not guilty. 2. If counsel for the defendant believes that a plea of not guilty by reason of insanity should be entered on behalf of the defendant, but the defendant refuses to permit the entry of such plea, counsel may so inform the court. The court shall then conduct such investigation as it deems proper, which may include the appointment of psychiatrists or psychologists to assist a psychiatrist to examine the defendant and advise the court. After its investigation, the court shall conduct a hearing to determine whether the plea should be entered. If the court finds that the entry of a plea of not guilty by reason of insanity is necessary for a just determination of the charge against the defendant, it shall enter such plea on behalf of the defendant. The plea so entered shall have the same effect as though it had been voluntarily entered by the defendant himself. 3. If there has been no grand jury indictment or preliminary hearing prior to the entry of the plea of not guilty by reason of insanity, the court shall hold a preliminary hearing prior to the trial of the insanity issue. If probable cause is not established, the case shall be dismissed, but the court may order the district attorney to institute civil commitment proceedings if it appears that the protection of the public or the accused requires it. F. Plea discussions and plea agreements. 1. Where it appears that the effective administration of criminal justice will thereby Be served, the district attorney may engage in plea discussions for the purpose of reaching a plea agreement. He should engage in plea discussions or reach plea agreements with the defendant only through or in the presence of defense counsel, except where the defendant is not eligible for or refuses appointment of counsel and has not retained counsel. 2. District attorney may agree to one of the following depending upon the circumstances of the individual case, to make or not to oppose favorable recommendations concerning the sentence to be imposed if the defendant enters a plea of guilty or nolo contendere, to seek or not to oppose the dismissal of an offense charged if the defendant enters a plea of guilty or nolo contendere to another offense reasonably related to the defendant's conduct, to seek or not to oppose the dismissal of other charges or not to prosecute other potential charges against the defendant. If the defendant enters a plea of guilty or nolo contendere, defendants whose situations are similar should be afforded similar opportunities for plea agreement. The trial judge shall not participate in plea discussions. The trial judge shall not participate in plea discussions. Notwithstanding the reaching of a plea agreement between the district attorney and defense counsel or defendant, the judge in every case should exercise an independent judgment in deciding whether to grant charge and sentence concessions, except as to proceedings resulting from a plea of guilty or nolo contendere which has not withdrawn. The fact that the defendant or his defense counsel and the district attorney engaged in plea discussions or made a plea agreement shall not be received in evidence against or in favor of the defendant in any criminal or civil action or administrative proceeding. CRCP 11. CRCP 11. Rule number 12. Pleadings, motions before trial, defenses, and objections.